हिस्टोरिकली रूल्स अराउंड मैरिज, इनहेरिटेंस, प्रॉपर्टी ये सब कैसे डिसाइड होते थे?
Today, we embark on a journey through time to unravel the complex tapestry of the Uniform Civil Code or UCC, tracing its origin and evolution. To understand the UCC, we must first grasp the diverse legal structure of pre colonial India. Before British rule, matters of civil law were primarily governed by religious, caste, or communal customs. Disputes concerning marriage, property, inheritance were more adjudicated by local authorities such as panchayats, qazis, pandits, applying respective religious or customary laws to each case. However, with the advent of British colonialism, a shift occurred in legal governance. British judges began codifying and organizing personal laws, creating a more uniform and centralized legal framework. This process led to the emergence of what came to be known as Anglo Mohammedan law, blending British legal principles with Islamic jurisprudence. Legal scholars like Henry Maine drew parallels between Hindu law and Roman law, highlighting patriarchal structures that disadvantaged women. Maine argued, akin to Roman law, Hindu law vested immense power in the male head of the family, often to the detriment of individual rights. Furthermore, scholars like J.H. Nelson shed light on discrepancies in the application of Hindu law, particularly in regions like Madurai district. Nelson criticized the imposition of strict Sanskrit law on diverse communities, advocating for a more nuanced understanding of local customs and practices. In the preface of his book, Nelson underlines that the customs of natives of Madurai district were particularly different from customs popularly ascribed to Hindus and judicially recognized by the High Court of Madras. He adds that the High Court applied strictest Sanskrit law to persons belonging to different tribes and castes. This holds true even today. There is no universal Hindu practice in India. Therefore, Nelson's purpose of the book, in his own words at that time, was to call attention to the absurdity and injustice of applying what is styled the Hindu law to the great bulk of the population of Madras province. As we navigate through these historical texts and commentaries, it becomes evident that the journey towards a uniform civil code has been fraught with complexities and divergent perspectives. Amidst the colonial lens, it is crucial to recognize the intricacies of the Indian legal system, which is far from chaotic, but rather highly evolved. It embraced the rich tapestry of socio cultural diversity across the subcontinent, rooted in traditional Hindu law's concept of dharma, the diverse models of judicial adjudication under Muslim rulers influenced by Persia, Arabia, Egypt, and Syria. So, therefore, it was a culmination of all of these aspects. It did have its own backlogs, such as application of a common Hindu law on a lot of people. However, it was still quite evolved for its time. This recognition of pluralistic political, social, and legal disciplines led to the exemption of non Muslims from Muslim personal law, demonstrating a nuanced understanding of India's vast expanse and diverse communities. Here we're talking about pre British era as well. However, the British colonial perspective often misunderstood this complexity that was existing before them, perceiving India's legal system as mere social norms enforced by informal traditional codes. This misconception overlooked the dispassionate formal adjudication inherent in Indian legal traditions, operating through normative letter of the law, albeit within a different culture and conceptual framework from the Western construct. As we delve deeper into the historical narrative surrounding the Uniform Civil Code, it's imperative to look at what happened in terms of the development of India's legal heritage. The discourse surrounding the UCC took a significant turn during the deliberations of the Subcommittee on Fundamental Rights. Visionaries like Meenu Masani, Hansa Mehta, Amrit Kaur, and B.R. Ambedkar championed the adoption of a uniform civil code, advocating for a unified legal framework transcending religious boundaries. However, their efforts faced opposition from other committee members who argued that the issue lay beyond the committee's jurisdiction. Despite the contention, the Subcommittee on Fundamental Rights proceeded with their discussions. When the list of fundamental rights was presented to the advisory committee, a crucial decision emerged. The advisory committee said that the rights can be divided in two categories: justiciable and non justiciable. In a close vote of around 5 is to 4, the subcommittee, led by Sardar Patel, opted to place the provision of the UCC in the non justiciable part, that is, the directive principles of state policy. Article 44 of the DPSP, enshrined in Part 4 of the Constitution, lays the groundwork for UCC. It states that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Importantly, the Constitution specifies that the state can only endeavour to achieve this common code rather than mandating its enforcement. This inclusion of the Uniform Civil Code in the DPSP reflects a delicate balance between aspirations of legal uniformity and respect for religious diversity. It underscores the evolving nature of India's legal framework and the ongoing quest for social harmony and equality. As we navigate the discourse surrounding the Uniform Civil Code, it's essential to examine the perspectives offered by legal commissions such as the Law Commission of India. In its consultation papers on the reform of family law in 2018, the Commission emphasized the celebration of Indian cultural diversity while cautioning against the disempowerment of specific groups within society. According to the Commission, the pursuit of legal uniformity through a UCC may not be necessary or desirable at this stage. Instead, the focus that the committee set should be on addressing discriminatory laws within various personal laws while preserving meaningful differences that contribute to robust democracy. Furthermore, it was said to be crucial to examine the changes that have occurred within different personal laws over time. Contrary to popular narratives, reforms in Muslim law had already taken place in the late 1930s, providing women with inheritance rights, legal identity autonomy, consent in marriages, and the ability to independently seek divorce in courts. The debate surrounding the UCC has also been intricately linked with women's rights. Women's groups have long advocated for gender just laws across all religious communities, emphasizing the need to address constitutionally enshrined inequalities between men and women. The Working Group for Women's Rights held that in a debate revolving around dichotomies of nation versus community, individual versus collective, majority versus minority, women as a category are rendered invisible. These women's rights groups were actually formed long before independence, and the women's movement demanded a UCC as early as in 1937. From the 1960s onwards, the discourse around the UCC was sporadically linked to women's rights, and later, especially in the 1980s, women groups started to vehemently push for the code as a means to ensuring gender just laws for women in all religious communities of India. In recent times, the media has provided a more differentiated picture than it had in the 1980s when it comes to the personal laws. At that time, more commentators focused on the aspects such as justice and gender equality and pay attention to all personal laws rather than putting their sole focus on what happens in the Muslim community. Nevertheless, the public debate in the 1980s had tackled the gender dimension of the personal laws only superficially. The primary issue when it comes to the implementation of the Hindu Marriage Act is also the implementation of the Act. This aspect deserves more attention when the government is talking about UCC. The question is, have the previously enacted personal laws been implemented well? Scholars like Nivedita Menon argue that even though the Hindu Marriage Act was enacted in 1955, there are many rural communities which do not follow it and decide disputes on the basis of their own community's traditions and practices. Even women from these communities prefer to go to local panchayats rather than formal courts as they consider them to be alien, distant, expensive, and decisions take a very long time. And they're not always decided in favor of women. Since issues of marriage, divorce, succession, etc. are civil in nature, even if a UCC is enacted throughout the country, Many rural and tribal communities may not follow it and continue with their own customs and practices. So, how much will enacting a UCC change the situation? Or rather, do we really need to have a review on how well these personal laws have been implemented and created a gender just society? Polygamy. How big is the issue in India? In 2005, in Rameshwar Chand Dakka and Rameshwari Dakka, the Supreme Court conceded that despite codification and introduction of monogamy, the ground reality had not changed much, and that Hindu marriages, like Muslim marriages, continued to be bigamous. In this case, the apex court was trying to award maintenance to a woman whose husband had challenged the validity of their marriage because of his previous subsisting marriage. The court had commented further that though such marriages are illegal as per the provisions of the codified Hindu law, they are not immoral, and hence a financially dependent woman cannot be denied maintenance on this ground. The Uttarakhand Uniform Bill makes polygamy illegal because it is against, according to the code, public policy and morality. However, how many women are being accorded the right of maintenance when caught in polygamous marriages? The government data on polygamy can be obtained from two main sources, the Decadal Census and the National Family Health Survey. Both have certain limitations. The census does not directly collect data on polygamy, rather, its incidence is inferred from the difference in the number of married men and the number of married women in the country. More married women than men points to the prevalence of polygamy. This brings up the situation where men have married more than once. Here, if you locate the data of the census, which is only last available from 2011 on marriages by religion, the total share of polygamist population amongst Hindus was 0.45%, amongst Christians it was 1.06%, among Sikh it was 0.39%, and among Muslims it was 0.90%. Therefore, the total share of polygamist population in India was 0.54%, which at that time had equal to around 65 lakh people. It is important to remember when looking at the census data that polygamy alone cannot be responsible for this gap. It can also be explained by men going abroad to work and leaving their spouses back home and then getting married again, which is also a very common practice in India and has been widely reported. In this case, the NFHS has held a more recent and slightly more directed survey. They asked women the direct question that besides yourself, does your husband have any other wife? The only issue here is that NFHS 5 does not look at the whole population. It only samples around 6 lakh households, which is less than 1% of the total number of households in India. In this survey, it was found that 1.9% of Muslims are engaged in polygamist relationships, 1.3% of Hindus are engaged in it, 2.1% of Christians are also a part of it, and 0.5% of Sikhs are a part of it. There are certain tribes that practice polygamous relationships as a custom, and that is around 2.4%, bringing the total of India to 1.4%. This data is particularly there in NFHS 5, that was from the year 2019 to 2021. As we delve deeper into the implications of legal reforms, it's imperative to consider the broader concerns of the UCC and the things that it aims to address, particularly in relation to women's rights and societal norms. One crucial aspect that demands attention here is the legislation on polygamous relationships. While strict laws can potentially bring about positive changes, the effectiveness of such legislations hinges on its implementation across all customs and religions. Despite existing laws within Hindu personal law prohibiting polygamy, certain customs in India still allowed for its prevalence, as evident by the census data and the NFHS 5 survey. This disparity highlights the need for comprehensive legal reforms that not only outlaw processes and practices like polygamy, but also ensures the protection of women's rights across all marital arrangements. Once made illegal, there are certain aspects that require attention. Nivedita Menon also argued that there are certain aspects of different personal laws that can be incorporated or at least adapted. Let's say within the Muslim personal law, the wives have certain responsibilities and rights in terms of maintenance. However, since it was illegal to be in a polygamous relationship in Hindu personal law, in case a man is having multiple wives, only one wife was recognized as a legal entity, having legal rights, and others are not allowed to have any legal rights or right to maintenance. These are certain gaps that the government has to now penetrate and manage in order to actually ensure the rights of women are preserved and entailed under the law. Recognizing the legal rights and responsibilities of all parties involved is essential for fostering gender equality and social justice. UCC must address other pressing concerns beyond polygamy. Initiating reforms within a focus on gender is paramount, ensuring that cultures are also not threatened by the threat of homogeneity. Additionally, the introduction of common legislations on issues such as domestic violence, property rights, and marital rape is also very crucial. While the UCC stipulates rights to property, it falls short in addressing other forms of abuse and coercion within marital relationships.